What's up, good people? And thank you for tuning in. My name is Kellen Patterson, and I am your host of your weekly entrepreneur briefing. I am a licensed attorney and practice in the state of California. This is a show that caters to the budding entrepreneur. You know, the person who has an idea, has the work ethic, has the right intentions, but maybe lack the resources and team that is at times necessary to cultivate a great business culture. Here at Budding Entrepreneur Briefing, we hope to provide you with useful content that centers around legal information that small business owners should know. Business and law are attached at the hips. There is no way you will want to operate a business and be completely ignorant to the laws or legal principles that affect your business. Doing business without considering the legal implication is downright stupid and can cost you your dream. As a practicing attorney, I receive calls all the time from business owners. Their legal issues range from simple matters that can be handled in a 15-minute phone call and all the way to an expensive litigation. However, there is one legal issue that always makes me want to say, why? Why would you do that? Can you guess what that issue is? Hint, it's in the name of the title of this video. The lack of a contract is a legal issue that I loathe seeing. So many times have I received a phone call from an industrious entrepreneur who says, someone owes me money and they won't pay, or my business partner is not holding up to her side of the bargain. What should I do? I then would ask, what does your contract say? And they will reply, what contract? I took her for a word. Ladies and gentlemen viewing this video, contracts are essential tools in the business person's toolbox. Just like a carpenter is expected to have a hammer and a screwdriver and other basic tools, a business owner is expected to have a contract. If you are a business person and you don't deal in written contracts, you're a fake and a phony, and I wish I never laid eyes on you. In all seriousness, business deals or arrangements should be placed in writing always. You might be thinking, man, I'm just starting and don't have the resources to hire an attorney. Well, if that is you, then you only have to remember what you were taught in elementary school when you were learning how to write a story. Your teacher explained to you that a good story will cover these basic questions: who, what, where, when, and why. A business contract, for all intents and purposes, tells the story of your business relationship. For example, who? Who are the contractual parties? Determine, verify, and write down the legal names of the parties, whether the parties are individuals or a company. Verification is important. You want to know if the person is who they say they are, or the company or corporation is a legitimate company or corporation recognized by the state you are doing business in. In California, the Secretary of State's office has a roster of all businesses who may lawfully do business in the state of California, either as an LLC or a corporation. Again, what? What is the business arrangements? Just write it out as detailed as you possibly can. For example, Acme Inc. promises to sell to vendor LLC 100 apples for $25. And then where? If location is important, sometimes it is irrelevant, but if it is, then describe the location as best as you can. For example, Acme Inc. will ship 100 apples to 123 Orchard Lane. How about when? This is important. When must the parties perform their respective obligations? In my experience, this is where most disputes derive from. Either a party did not produce something in time, or a party failed to pay in time. When this clause is spelled out in writing, each party then can hold the other accountable. And lastly, why? This is important to provide context to the business arrangements. However, it may not be legally necessary, but if you are drafting a contract without the assistance of a lawyer, likely you are leaving out a bunch of clauses and information to cover up loopholes. A non-lawyer drafting a written contract and explaining why the parties are entering into a contract helps to fill in the overall picture of the business relationship and helps to illuminate the subtle expectations of the parties. Now, after you cover these basic questions, all parties to the contract should date and sign the contract. Having a contract need not be notarized unless the law mandates it. However, in most contractual situations, you don't need it notarized. A copy of the signed contract should then be given to each party, and a duplicate should be stored electronically with the original filed away safely. And then voila, you have a contract. It is really that simple. Now, if you do have budget for attorney to review and or draft a contract, you should reach out to a licensed attorney in your state. It is always good to have a trusted attorney that you can rely on throughout your entrepreneurial journey. Okay? All right. Good. Well, that's it for this video. If you like what was shared here, please like this video and subscribe to this YouTube channel. We will be uploading new content weekly. For those who do subscribe to our channel, we will take suggestions for future topics. And if you are a California resident, please feel free to reach out to me in my information below. Okay? All right. To all the budding entrepreneurs out there, stay motivated, stay busy, and stay smart. Peace and blessings.